WFT.
Hi, good morning, everybody. Jeff Vastola here to give you some free legal
The
advice.
views and opinions expressed in this content
Bear with me while we get through the intro
those of
here.
850 WFTL. Hey, we know it's early. But what better way to start your day than by getting free legal advice? This is Vastola on the Law with your host, attorney Jeff Vastola, featuring 30 minutes of free legal advice. Call in now with your questions. 877-850-8585. That's 877-850-8585.
Good morning, my beautiful wife.
Now here's your host, attorney Jeff Vastola.
Good morning, everybody, and thank you so much. This is Jeff Vastola, your host of Vastola on the Law. I'm here every week, Saturday morning at 7:30 to give you free legal advice. I am on the radio, and I am on Facebook Live. If you'd like to watch the program on Facebook, then just request me as a friend on Facebook, and all you have to do is be on at 7:30, and you'll get a pop-up saying that I am now live, and you can click over and watch it live. I got some communication from a radio show listener that apparently it's a little bit distracting and perhaps even annoying that I'm doing the show on Facebook Live. For those that are listening on the radio, and for those that are listening on the radio, I apologize, but I feel that the Facebook Live program has enhanced the program, so I'm going to keep doing that. I also understand that we are having some significant glitches with the radio show, and we will continue in our efforts to try to work through that. But anyway, that stuff out of the way. Good morning to everybody, and bear with me today because today's going to be a little unusual. I see Patty's watching. Good morning, Patty. Nice to see you. If any of you are close or look at my Facebook, then perhaps you are aware of this, but I want everyone to please pray for my dad. My dad is currently in the Gardens ICU on a ventilator fighting COVID. If you don't know, my dad is a physician and has kept his office open since March when COVID hit, and it finally got him. So I'd just like everyone's prayers. He's fighting, so thank you. Today I have really no specific topic in mind. I'm going to be going through quite a few cases from the Florida Law Weekly, which I think are very interesting. Thank you, Patty. So, as always, this is a free legal program. To the extent that you can hear me on the radio show, that we're not having glitches, I would love for you to call into the program. Good morning, Terry. Nice to see you, and thank you. I appreciate that. If you'd like to call into the program, you heard the number. It's a toll-free number, and I apologize because I am a little bit distracted this morning. I should know the number off the top of my head, but let me just pull up one. Let me see here. It's 877-850-8585. That's the number to call into the radio show if you have a question of your own. You can ask me anything you want. If I know the answer as I'm sitting here, then I will give you the answer as best I can. If I don't know the answer to your question, then I'm going to research it. I'm going to make it my topic for a following week's program, and then you'll get your answer for free because this is free legal advice. So let me see. This might be Sharina telling me that I've got no connection again. Let me see if this is Sharina. No.
You're good.
Not. Okay, thanks, Sharina. It's sorry. Every time my phone chings now, I look at it. So, all right. Let me try to get through some of these cases, and they're interesting cases. And hey, Uncle Jeff, how you doing? Nice to see you. Yeah, I didn't really have an outline plan today. And I'm going to try to get through some of these cases. But as I mentioned, if you want to call into the show, it's 877-850-8585. Let me see.
You can talk about hit and run cases.
Thank you, Sharina. And Sharina, my board operator's making a suggestion for something to talk about. It's not that I have nothing to talk about. It's just that it's that's not the problem. So Patty wrote me the question, what do you do if someone gets better after an injury? Well, you thank God. That's one thing you do. I think more appropriate for a show like this would be when somebody's injured, what do you do to make sure that they get the best recovery that they could possibly get? That's an excellent question. And in a sense, Patty, you asked that. A lot of people come to me after an accident and they've been injured and they've been to an urgent care, or perhaps they've been to the emergency room and they've been given some immediate treatment to rule out any emergent conditions. And then they're given some discharge paperwork that says, hey, follow up with this doctor or follow up with your own doctor. That's good advice to follow up, but the problem is sometimes, depending on who's being suggested in follow-up, it's not really appropriate for the symptoms. And so that's one reason to consider using a lawyer, at least one that's experienced in personal injury work, because what I've learned over the years, and I've been doing it for 24 years now, is, hi Melissa, good morning, is that the treatment has to be pertinent to the symptom. Because if you're going to see like a musculoskeletal specialist, which would be either an orthopedic doctor, a chiropractor, but yet your symptoms are truly nerve related, sure, I mean, you can treat the symptom, but that's the proverbial Band-Aid. You're not really fixing the problem. You need to get to the root of the problem, no pun intended, because it's a nerve root, but you really want to go see perhaps a neurologist to get some neurological testing done to find out what is the origin of the injury so that you can figure out where it's coming from and then truly not just Band-Aid the symptoms, but you can perhaps fix the symptoms. Now, they're not always fixable, which again was Patty's question, what do you do when somebody gets a recovery? But it's important to get appropriate treatment for the symptoms, so keep that in mind. If anybody has a case and you have questions about that, feel free to call me. Not only do I offer you this telephone number here to get into the radio show, which is 877-850-8585. Thanks, Vicky. But my cell phone, you can call me anytime. That's Patty. My cell phone, if you'd like to reach me, is 833-VASTOLA. Call me with questions about anything you want. Can you get recovery money? Well, of course. I mean, thank you, Patty. I appreciate you keeping the show moving. Yeah, if you've been injured in an accident, then that's oftentimes why people go to a lawyer. It's not always the reason people go to a lawyer, believe it or not. Sometimes people go to a lawyer because they just don't know what they're supposed to do if they've been involved in an accident. I think most people that have not been involved in an accident, and most people that, that thumb their nose at personal injury claims and claimants and lawyers, automatically assume that it's all about the money. And if you drive around town and if you look at the billboards, I mean, it really does give you the impression that it's all about the money. And that's just, sometimes it is about the money, but sometimes it's not. Sometimes people genuinely just don't know what they're supposed to do. So if you're in a situation and you've got questions, you can call me, and you can call me without an obligation of hiring me. Just ask me questions. That's what the number's for. It's 833-VASTOLA. That's 833-827-8652. That's the number to call my cell phone. You can call me anytime. Call me on the weekend, call me at night. If I don't answer the phone, then leave me a voicemail message and I'll call you back, unless I've blocked you. And I say that because there's one person specifically that was taking too much advantage of the free legal that I offer, and ultimately after several warnings I had to block them. So I hope that doesn't happen to you, but it might. So let me just get through a couple of these cases. I've got my 30 minutes to fill, and this will hopefully keep me distracted. So the first case that I pull up, by the way, this edition that I'm reading from today, it's the Florida Law Weekly, and it's from October 23rd, 2020, just about 2 weeks ago. This one is just absolutely full of interesting cases. I don't know if you can see that, but every time I earmark a case, I mean, that's one that I want to talk about for one reason or another. And usually I'll get maybe 2 or 3 cases out of one of these editions, but this one has probably at least 8 or 9. This is a what we call a tort. A tort is a civil wrong. It's oftentimes negligence. A car accident is a tort. A slip and fall is a tort. Negligence is, generally speaking, a tort. A tort can also be an intentional act, but tort is a civil action, not a criminal action. And so this case falls under the category of a tort. It falls under the subcategory of premises liability, which is oftentimes like a slip and fall or a trip and fall case. And what's interesting is that it didn't really focus on the injury or the claim. It focused on trial procedure. And I just wanted people to understand that as lawyers, when we're getting ready for a case, oftentimes the trial judge will say, well, I'm going to limit your time to voir dire, and that causes us lawyers to get really anxious because we don't want to be limited in how much time we have to pick a jury. The voir dire process is picking the jury selection. And there are some judges out there that say, I'm limiting your time. There's a lot of case law on whether or not a judge can limit time for jury selection or not. And this most recent case out of the 1st District, which is up there in Tallahassee, essentially says that when the judge told the lawyers, as the case was about to begin, that the judge was going to limit their time to voir dire to 1 hour, one of the attorneys objected to that. And as the case proceeded, and as he was obviously requiring more time for his voir dire, and the court interjected to say, okay, you're pretty much done because you've gone over the 1 hour I've allotted you, the attorney never objected again. He only objected at the outset, never objected again. And that's one thing about being a trial lawyer, is that you have to object all the time. And to be very honest with you, that's one thing that I don't like doing. I really don't like having to constantly place objection on the record, but it's what you have to do. Oftentimes it seems redundant, especially if you're one of the parties sitting in the room. You're like, dude, you already objected to this. Why are you doing it again? Well, it's because we have to, because the rules and the case law require it. And ultimately, the limitation of time on jury selection, as this case points out, which is the Tallahassee Housing Authority versus Kenneth Prather, essentially says the court can limit the time for voir dire depending on the circumstances and depending on whether the lawyers who are asking for more time actually need more time. And what it boils down to essentially is if the lawyers are just needlessly wasting time and it's not apparent that they needed extra time, then it's not an abuse of discretion for the trial court to limit their time. It can be an abuse of discretion if the trial court says, I'm only giving you an hour for voir dire, and then it becomes patently apparent that the lawyers are needing more time for legitimate reasons and the court refuses to give them more time. But what's interesting in this case is that the lawyer actually convinced the trial judge that the trial judge was incorrect in not allowing more time. So the trial judge reversed himself after the case was over. After the case was over, there was a verdict rendered, the jury went home. After all of that, the trial judge said, you know what, I was wrong, I'm going to reverse myself, you're going to get a new trial. Well, the other party didn't like that result because they had won at trial, and they said, wait a minute, we don't think that your decision was wrong, Judge. They filed the appeal, and sure enough, the appellate court says that the trial court did not make a mistake. So even though the trial judge had reversed himself, the appellate court said, no, you're good, you didn't make a mistake. And they affirmed the ruling of the trial, and there you go, the case is over. But anyway, interesting to me as a trial lawyer, because as cases come out, sometimes it will change the law, but this is a clarification on the rule of limiting time for voir dire. Similarly, here's another case, again, under the general category of torts. This one has to do with nursing homes, nursing home negligence, and a plaintiff's request to add a claim of punitive damages. Now, again, this is procedural. As a trial lawyer, this is interesting to me because this is the kind of work that I do. The plaintiff did everything right here. The plaintiff filed the lawsuit. When you are intending to bring a claim of punitive damages, you don't include that in the original lawsuit. Procedurally, what you have to do is you have to file your lawsuit, You have to build up the facts of the case to be able to demonstrate that you're going to meet the threshold for punitive damages, and then present that to the court in the form of a motion. It's called a motion for leave to add a claim for punitive damages. And the court will have a hearing, an evidentiary hearing, so the court can actually consider the evidence that you've found and would be admissible to prove, to substantiate that you have a claim for punitive damages, because that's a much higher threshold than just a regular standard negligence threshold. And the reason for that is because the damages that you're able to recover from a punitive claim are for punishment, whereas the damages that you're able to recover from a standard negligence claim are just compensatory, which means they're there to compensate the plaintiff. So if you can elevate your claim to the point that now you're looking for damages to punish the defendant for intentional or reckless or wanton behavior, then the value of your claim is much greater than it otherwise would be. And so in this case of East Bay NC LLC versus Melanie Reddish, she's a personal representative, so there was a decedent, somebody in the nursing home passed away. We don't know a lot about the facts, but essentially the plaintiff and the plaintiff's lawyer did everything right here. They filed the standard negligence claim. They filed the motion for leave. Hey, Chelsea, good morning. And the court held a hearing and granted the motion. But unfortunately for the plaintiff, and this isn't as though the door has slammed shut, this is going to be a redo, but the plaintiff won because the trial court said, okay, I see enough information and evidence here to rise to the level of punitive damages, and issued the order. The defendant immediately filed an appeal. So this hasn't gone to trial yet. This is very early on in the early stages of litigation, but they're already in an appellate posture because the defendant didn't like the ruling from the underlying decision. So the appellate court said, we're sorry, trial court, but you didn't do what you were supposed to do in the written order. Not to say that the court didn't do what it was supposed to do during the hearing, but the written order did not set forth all of these things that the law requires the trial judge to put in the order granting a motion to add a claim for punitive damages. And so because the court didn't do what it was supposed to do, the ruling for punitive damages was reversed and sent back to the trial court. So basically they're back to square one. And undoubtedly the plaintiff will again file this motion for punitive damages, and assuming nothing has changed, I would assume the second time around the trial court's order will be very lengthy and very specific so that it complies with the appellate court's guidelines. But anyway, that's the kind of thing that will oftentimes bog down a case in litigation for what is years. You know, when I tell people that it's going to take you at least 2 years to get to court, they look at me funny. They're like, well, that's not how it works on TV, you know, and of course it doesn't. But in real life, that's how it works. And it's because of situations like this. I mean, very, very early on in litigation, you've got an issue being presented to an appellate court. That appeal can take 6 months to a year and a half, depending on the extent of the appeal and whether the appeal is going to be appealed and everything else. And that's just at the very early stages of litigation. So you can see why cases drag on forever. Hey, good morning, Suzanne. Nice to see you. So, clients that express frustration to me about how long it's taking a case to get through the system, believe me, I empathize with you, because as a contingency fee lawyer, I don't get paid until the case is over. So believe me, I feel your pain. Another interest.
Delray Beach.
I'm sorry, say the name again?
Anita from Delray Beach.
Okay. Those on Facebook Live, we have a caller into the show. Anita from Delray. Good morning. What can I do for you, Anita?
Good morning. About a year ago in my community parking lot, somebody backing out hit the back fender of my driver's side. And, of course, I didn't know who it was, but there was red paint from their car on my fender. So I've been looking for a car that had red paint. I was red and might have a, show it on their passenger side. Well, after looking for quite some time, I discovered such a car. But I didn't know how to go about, how to address the person. And now they've gone about fixing it, but I did take photos of the license plate and showing the damage on their car as well as my own car. What can I do about this at this point in time?
Well, there's a couple things that you can do, but I'll forewarn you that this is a case that you're going to lose if you were to file a lawsuit, because you just don't have enough evidence, at least without some surveillance video, to prove who it was. And that would be my first recommendation, is to go to the HOA or the COA or whatever it is, to say, do you have any surveillance of this area of the parking lot? And if it's been a while since it happened, even if they do have surveillance of that area of the parking lot, there's a good chance that it's already been recorded over. So anybody watching, anybody listening, understand that after an accident, it is incumbent on you to request surveillance immediately, because surveillance is oftentimes looped to re-record any 48 to 72 hours or so. But anyway, if you don't have any more evidence than what you've put together, my recommendations are this. One, find that person, be very cordial, and just approach them in a very nice way to say, hey, did you happen to bump my car? I see that you've got some damage. The damage to my car was the color of yours, so on and so forth. And just let it play out. If the person is a genuine, ethical, moral person, then they might be willing to pay for your damages. If not, then I'm not going to recommend that you bring any kind of legal action against the other person that you think did it, because when you file a lawsuit, you're going to have the burden of proof, and what you have standing alone is not enough to satisfy the burden of proof. So my second suggestion is, look to your automobile insurance policy and look to see if you have collision coverage. It's an optional coverage, but it's a coverage that's there so that any damage to your car caused by really any event will be paid for by your insurance company, less your deductible. Okay.
That wouldn't pay me because I would end up costing me forever for that damage because it's going to, they're going to raise my rates, first of all. So that wouldn't pay. And I know who the person, is now. It took me a long time to find them. But I don't know, they see me every day, and yet they've never said anything to me. So.
Well, maybe they don't know that it was your car. Maybe they don't know that they hit you. Believe me, I've heard that before. I've heard people say, I had no idea that I hit the other car. So give that person the benefit of the doubt. Approach them gently and just see if you can work it out. That's going to be your best bet. If you've looked into the insurance route and you've decided not to go that route, then that's up to you. But believe me, that's a coverage that you're paying for. So when you utilize the coverage, then the insurance company is not allowed to penalize you. And if they do, then we have another issue to talk about.
Uh-huh.
Okay?
Okay.
So,
yes.
so
and you
three...
think I should just say, did you happen to hit a car? I mean,
yeah.
They've gone about and actually repaired it. I've taken pictures, though, of the car when it happened.
Just very politely. Just very politely. So, Anita, here's the three things I'm suggesting you do. Go request surveillance, approach the other driver, and look at your insurance policy. Okay? All right. I'm sorry it happened. All right. Take care. Have a nice day. Thank you, Sharina. Another case that I wanted to talk about.
From Delray Beach.
Oh, okay. Hey, cousin Cheryl, how are you up in the Northeast? Don, good morning. How are you?
Good morning, Jeff. This is Don. I'd like to ask you just a little something about what does it mean when a judge orders discovery?
Well, first of all, a judge does not have to order discovery. According to the rules of civil procedure in Florida, when a lawsuit is initiated, the parties are entitled to take discovery, which comes in many forms. You've got written discovery, which is typically the very first thing that's done. And those are what we call interrogatories. Those are written questions. And the recipient, the other party, has to provide written answers to those written questions under oath. You sign what's called a jurat page in front of a notary. So those are sworn testimony, the same way a deposition or live testimony in court would be. You can also send what are called a request for production, which is a request for documents or things. You can do a request for admissions, which is you sending a written statement to the other side, and they have to admit or deny what you've stated. And then, of course, you get into depositions. Depositions are a form of discovery. Site inspections. Sometimes we'll do site inspections so that evidence can be taken from the site. So there's all forms of discovery, and it does not have to be court ordered because all of these things are contemplated in the rules. Now, if a judge orders discovery, it's likely because somebody is looking for something above and beyond what the rules contemplate. So, as an example, typically one party is only allowed to send 30 interrogatories to the other party. That's what's in the rule. But nowadays, we're getting interrogatories with 40, 50, 60 questions. And so if I object to it, then there will be a hearing. Good morning, Sarah. Nice to see you. And at the hearing, the side that propounded the discovery is going to have to explain to the judge why they want 60 interrogatories instead of 30. So after hearing argument, the judge will make a decision. And if the judge thinks there's a good reason for it, then, thank you, Sharina, then that would be court-ordered discovery. And if it's court-ordered, then you have to, comply, and you have to do what's being requested. Don, I'm sorry, but we are out of time. Sharina just gave me the warning bell. So if you have any follow-up, certainly you know how to reach me. Don is a regular. Thank you for calling in. I appreciate that. Thank you, everyone, for watching. And please, I'm going to wrap up the show with this. If you didn't hear me, thank you, Don. Please pray for my dad. My dad is in the ICU on a ventilator fighting COVID, and so we would truly appreciate all of your prayers for my dad. Thank you. God bless. See you next week.